Greetings, dear colleagues, students and cadets. Let me introduce myself. My name is Kosяченko K. I am an associate professor of the Department of Civil and Legal Disciplines at the Dnipro State University of Internal Affairs and candidate of legal sciences. Today we continue the consolidation of discipline financial law, and the next lecture is financial and legal norms and financial legal relations. And the issues we will consider, this first is concept of legal norms of financial law and their types, and financial legal relations, concept, function, content, and features. So let's start. Our first question is concept of legal norms of financial law and their types. Relations arise in the process of mobilization, distribution, and spending of centralized and decentralized funds by the state, and its bodies are regulated by financial and legal norms. Financial and legal norms are mandatory prescriptions of competent state bodies regulating the mobilization, distribution, and use of funds of centralized and decentralized funds, expressed in a categorical form and ensured by state coercion. Depending on the method of influencing participants in financial relations, which determines the nature of legal rights and obligation, financial and legal norms are divided into three types. It's binding, prohibitive, and authorizing. Binding financial and legal norms prescribed to carry out certain actions aimed at the mobilization or spending of funds by the state. Binding financial and legal norms are contained in all financial laws and regulations. Prohibitory financial and legal norms prescribe not to take action that violate or undeterminate financial discipline. Mandatory and prohibitive norms are similar in their certainty, categoricalness of form, and prescriptions of prescriptions contained in them. In the authorizing financial and legal norms, the state gives the participant of financial and legal relations the authority and carry out certain positive actions. According to the content, the norms of financial law are divided into material and procedural. Material, financial, and legal regulations establish the types and amount of funds that must go centralized and decentralized funds from legal entities, the amount of expenses that will be financed from these funds, the sources of credit resources, contain the material content of legal rights and obligations subject of financial legal relations. And procedural financial and legal norms determine the procedure of the activities of state bodies for the mobilization of funds in centralized and decentralized funds, the procedure for the implementation of obligations to contribute funds and spending by the other party of financial and legal relations. The structure of financial and legal norms, the internal structure, the component parts consist of hypothesis, disposition, and sanction. The hypothesis of financial and legal norms determines the conditions under which individuals and legal entities may have legal rights and obligations in the field of financial activity provided for the norm. These conditions are always specified, expressed. The basis of the norm is the provision which contains the requirements of the norm, establish the rights of obligations of the subject of financial relation, always expressed in the certain form. The sanction of the financial and legal norm contains indication of unfavorable consequences for its violator, and violations of financial legislation are subject to disciplinary, administrative, and criminal measures. But specific financial measures are also applied to violation of financial discipline. Second question of our lecture is financial legal relations, concept, function, content, and futures. Financial and legal relations are a legal form of manifestation and consolidation of financial relations. Financial legal relations are social relations regulated by the norm of financial law, the participants of which act as buyers of legal rights and obligations who implement the prescriptions of these norms on the formation, distribution, and use the state funds. Financial and legal relations in the mechanism of legal influence on state finance perform three main functions. First, indicate the circle of persons to whom the effect of the financial and legal norm is extended at a specific time. Second, it establishes the specific behavior of the legal entities and citizens in the field of mobilization, distribution, and use of funds which they must adhere to. And third, is a condition of the possibility of implementing legal means to ensure the subjective rights and legal obligation of participants in financial relations. The material content of financial legal relations is a behavior of subject, for example, payment of fees. And the legal content is subjective legal rights and obligation established by financial and legal norms. Financial and legal relations have their own characteristic. First, they arise only in the field of financial activity of the state and are related of the mobilization, distribution, and use of centralized and decentralized funds. That is, they always have a monetary nature. Secondly, one side of the financial and legal relations is the state, in the form of legislative and executive authorities, especially often in the form of financial and credit authorities, which are granted authoritative powers in relation to the second participant in this relationship. There is no equality of parts in financial legal relation. The state authorities part to financial legal relations have the right to put into effect legal means of protection that ensure the financial prescription of the state because it acts in the interest of the state as a whole. Thirdly, the particularity of financial legal relations is also the fact that their origin, change, and termination do not occur at the will of the parties, but are related to a financial and legal act. So, our lecture is over. The next topic of next lecture will be legal regulation of financial control in Ukraine. Thank you for attention.